Good afternoon. This is Judge Elisa Bettis presiding over the 210th District Court criminal docket for January 17, 2023. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, would you call our next case, please?
Yes, Judge. Annex, may we have Hernandez? Marcus Hernandez.
Good afternoon, Judge. Can you hear me?
I can. Thank you, Mr. Spencer. Is that Mr. Hernandez?
Yes.
Okay.
In cause number 2022-0D04726, State of Texas versus Marcus Ryan Hernandez. Announcement of counsel, please.
Javier Salcedo, Assistant District Attorney for the state, ready to proceed.
Good afternoon, Your Honor. Joshua Spencer on behalf of Mr. Hernandez.
And Mr. Hernandez is appearing remotely from the jail annex. We are scheduled today for a bond hearing. Mr. Spencer, you may proceed on that.
Thank you, Judge. Your Honor, Mr. Hernandez is a young man. He is born in 2001, so it makes him like 22 years old. Judge, I'm not exactly sure if he has any priors. I don't think he has. But in regards to this case, I know he resides with his mom. His mom is here to support him. He lives at 656 Pablo Sivals, S-I-V-A-L-S. That's in El Paso, 79927. If the court would consider releasing him on bond, he would reside there with his mother. He was working, Judge. He works at Speaking Rock as a dishwasher, and that's basically what he does. And I'm not sure where he's at with school, but that's a little bit of just of his basic background. With regards to this case, Judge, he's indicted for on a few counts on some serious allegations, but there are two complaining witnesses in this case. One is the homeowner, and the other one is the homeowner. I guess would be I think it's the grandmother, and then there's another man or the grandson that lives there with the homeowner. That's the complaining witness on the burglary. Judge, it is my understanding that my client, there should be some co-defendants in this case. My client was contacted by his uncle and his cousin, and it appears that the complaining witness for the ag robbery, Jesse Chavez, was dating my client's cousin, who is the daughter of the uncle, okay, who is a complaining witness in this case. One of the complaining witnesses in this case. No, I'm sorry, co-defendants. The cousin and the uncle, they're both also co-defendants.
Mm-hmm.
But so my client gets a call from his uncle saying, hey, Jesse Chavez is beating my daughter, and she needs to leave the house, and she needs to help me get her stuff to get out of the house. So he goes to the house with his uncle and his cousin to remove her property from that residence. And that is what led to the events that occurred to this case. Okay. And that's where the allegations come out and so on and so forth. This was a one-time incident that we don't believe that this is something that would mark as would signify or show that Mr. Hernandez is a danger to the community, or he's a future danger. This is a single isolated incident where he's helping his cousin and his uncle get out of that residence. Now, there was obviously some hostility and some fighting going on at the residence as a result of going over there. But my client's role in this transaction was minor, minimal at best, and as a result, we're here today, and we'll have to address these. We'll address these allegations. But with regards to the bond, Your Honor, my client is a dishwasher. He has a very low access to income. Like I said, I believe this is an isolated incident. He is not a future danger to society or to the community. He has strong ties to El Paso, so he's not a flight risk. I don't believe he has a passport, but if he did, he would surrender that to the court or to pretrial services if necessary. But I'm not exactly sure what the other bonds are on the co-defendants, but certainly because my client is, I think, because his whole participation or his involvement in these offenses is minimal. We would like to ask the court to take that into consideration and have that reflected on a reduced bond for Mr. Hernandez.
And is
We ask
he,
the court. Go ahead.
I'm sorry, Mr. Spencer, is he at a 200,000, 150 cash surety, 50 PR? Is that what he's at? That's what I'm showing.
Yeah, I believe so, Judge. Yes, I think that's right.
Okay, go ahead. I didn't mean to cut you off.
No, and that's all I have, Your Honor. We'd ask the court to reduce those to play those factors into consideration. My client's age, isolated incident, not a danger to society, and his strong ties to the community, Judge. Nothing further.
Mr. Salcedo, are you handling this one?
Yes, Your Honor. Yes, ma'am. And Your Honor, at this time, we would oppose any type of reduction, much less any type of PR bond or anything of that nature. While Mr. Spencer makes the argument that this is an isolated event, there is a pending plea file for Mr. Hernandez having been arrested for possession of THC and alprazolam, and this is back in April of 2022. As to this case, there are two other co-defendants. The individuals that break into this house are Marcus and another gentleman by the name of Nicholas. Officers hear that Marcus, when they talk to him, he says, and I lost it. He says, I was there and I was intending to kill Jesse, being Autumn's boyfriend or ex-boyfriend. Now, they both go in, Marcus, Nicholas, they have a handgun. They're pointing the handgun at the homeowner, a 65-year-old lady, the grandmother, telling her to move out of, excuse the language, move out of the fucking way because we're coming after Jesse. And so whether there was incidences of violence between Autumn and Jesse, they could have called the police. They could have done something other than break into the house, pointing a handgun at an elderly individual, telling her that they're going to kill Jesse. And if she doesn't move out of the way, they're going to kill her too. So that is a danger to the community, Your Honor. That is a threat. There are concerns that this individual knows where the complainant witnesses live and that they might go out there and do something. And so we would oppose any type of reduction, and we just ask that the case move forward to the next setting.
Marissa, can you confirm for me what the bond amount is? I think initially JMAG had him at there. I see a bond order for 75.25, but then I think it went back because there were multiple complainants and they doubled the bond amounts, count one, count two, basically, and then it went up to 75. I'm sorry, 150.50.
Yes, Your Honor, it's a 200,000 split bond. It's 150 perpetuity or cash and 50 PR.
Okay. Anything else, Mr. Spencer?
Yes, Judge. As far as a break-in, I don't believe there was a break-in. I don't think there's any signs of an actual break. I think they were let in, and all the property, they did take all of Autumn's stuff. The cousin, the girl that was there, they did get her stuff out of the residence. So
And Mr.
So-
Mr. Spencer, you need to look at the photos and look at the police report. It says, I observed the door of the residence to be damaged and consistent with being kicked in. The door frame was damaged and both the bottom and top locks were still in the locked position. When they ask your client if he broke the door, he says, who else could have? So that's not very accurate, Mr. Spencer. They broke the door and they broke into the residence. There are photos of that.
Okay. Well,
Who allegedly pulled the weapon out?
It was, according to the report, Your Honor, Mr. Nicholas is the one that had the handgun, but Marcus said it belonged to him.
Oh.
And there was a Glock 19 that was found at the scene.
yeah, I believe, if I'm not mistaken, I mean, the police were called and my client never left. They stayed there till the police showed up.
All right, so I'm going to deny the request to reduce the bond based on the nature and circumstances of the offense and the future safety of the community and the victims. So I think we have our trial setting. Thank you, Mr. Spencer.
Thank you, Judge. May I be excused?
You may. Who's next?
Thank you.
Staying on page 23, Judge. And annex, may we have Angie Martinez?
And this is one she has, she actually has two cases. So the other cause number is 2022 0D03563. Is Mr. Huerta here?
Yes, Judge.
Okay, so we need to call both of those, and then I have PDs on 5686 and Mr. Huerta on 3563, although I don't think there's a bond reduction request on the 3563. So go ahead.
In cause number 2022 0D05686 and 2022 0D03563, State of Texas versus Angie Lisa Martinez. Announcement of council, please.
Javier Salcedo, Assistant District Attorney for the state, ready to proceed.
Your Honor, privilege.
Go ahead, Mr. Huerta.
I apologize. Jonathan H. Huerta, privilege, Your Honor, to be here on behalf of Angie Martinez, ready to proceed.
And you were on 3563. Okay, and then Mr. Huffman. Counsel.
Yes, Judge. Rick Huffman on behalf of Ms. Martinez on 5686.
And so we have one, and of course, Ms. Martinez is appearing remotely from the jail annex. This was originally scheduled for a bond hearing solely on 5686, Mr. Huerta. But I was reviewing your client and her cases. She had the case, of course, that you were appointed on. I'm going to go ahead and allow PDs to go forward on their bond request, bond reduction request, but in looking at the orders appointing, I'm not sure, Mr. Huerta, I'm not sure if there was a reason why. Myrna, did we look that up? Why Mr. Huerta wasn't appointed on the cause number 5686? Did it need to be PDs?
I'm still checking the dates on that, Judge.
So I show JMAG appointed public defenders on November 29th of 2022, but Mr. Huerta was appointed back in 2021 on 3563. I'm just wondering if maybe the wheels might be different for the different types of offenses. In any event, Mr. Huffman, you may proceed on your bond hearing. Her bond, I believe in your case, is 50,000 cash surety. Mr. Huerta's case, it's 150,000. And then she still has the misdemeanor 2022 0C02072, $5,000 holding her there, and Mr. Huerta is appointed to that case. So let's go on to 5686 bond hearing, Mr. Huffman.
Right, Judge, and Your Honor, we're hoping the court will consider the bonds on all the cases without obviously objection from the state. Judge, Ms. Martinez is 40 years old. She's a U.S. citizen, a lifetime resident of El Paso. She lives with her mom, dad, and her 12-year-old son. I spoke to her dad, and he confirmed that. She's been living at that address for 7 years. She works at Joyful Daycare. Basically, that's a daycare that her sister owns, and she's been working there for 5 years, and she can go back there. Your Honor, it's my understanding she was doing well on PR bond. She was reporting and doing the things that were required of her. And to be honest, Judge, this new case caught her completely off guard. I believe this new case is the grounds for revoking her PR bond in the other cases. Judge, I've looked at the report on this case. I don't know if we're still missing discovery, but the allegation is a manufactured delivery of over 4 grams of fentanyl, about $100 worth of fentanyl, Judge. But there's no video, no audio, no labs, no pictures. There's a mention of a video in the report, but I don't know if that video still exists. There was no arrest made that day. I'm still trying to figure out how they intend to link Miss Martinez to the actual person they are alleging did this. Now, she's been in jail, Judge, for about almost 2 months, and I've asked her if she can raise any money to pay a bond, and her family's very limited at the moment. Her sister needs a lot of help at the daycare, and the money that they can raise is very, very limited. She's thinking maybe in the range of 500. And Judge, I would just like to reiterate that I'd ask the court to consider her performance on PR bonds and really the lack of evidence on the manufactured delivery case on this new case, Judge. So we're respectfully requesting a reduction of her bond. Thank you, Judge.
All right, Mr. Salcedo, you're prepared to go forward on with both cases? Reviewing
That's correct.
Okay, go ahead.
Yes, Your Honor. And Your Honor, as to both cases, I would oppose any type of reduction. And the reason for that is the following. I'm not sure where Mr. Huffman got the information that his client was a lifelong resident of El Paso, Texas. She does have a long history out of California, spending time in California, spending time in prison over there for whether it's under the influence of controlled substance, to unauthorized use of a motor vehicle, to taking a vehicle without consent. She's done up to 16 months in prison, possession of a narcotic, evading police officers. And so she does have a long history. I counted at least 30 pages that she has of prior convictions. As to this case, the one ending in 5686, in this particular case, undercover agents are buying fentanyl from Ms. Martinez. And so there is a report where they do an undercover buy, they buy $100 worth of fentanyl, and we are waiting for the lab for that. And so I think they buy 36 blue pills. They were tested there at the police office with narcotic kit and tested positive for fentanyl. And one of the pills weighed, or the full amount that they had was 5.2, but we're trying to get a better lab to provide. And so given that the long history that she has, no ties to the El Paso community, this offense for buying from undercover agents, and then in the UUMV, that happened in December of 2021, and also the assault that she has in March of 2021. And so she gets out on a PR bond and she commits a new offense. And so she's not compliant with the PR bond conditions. She's not asking, she's not doing what she's been asked to do. So at this time, we would oppose any reduction.
Okay. And Mr. Huerta, did you have anything to add in terms of the bond reduction?
Your Honor, without sounding redundant, I do agree with Mr. Huffman. I would leave it to the court in terms of, I do believe that the bond is rather high. She may not be exactly a lifelong resident, but her child is here in El Paso. There's nothing on to indicate that she's been separated from her child or removed from her child or danger to her child, much less a danger to the community, with the exception of what is allegedly being charged for. I would offer, Judge, that to the court that my client is just it seems in the wrong place in the wrong time, Your Honor. The prior offenses, while clumped together, do look more egregious, but taken individually, Judge, they're sort of your run-of-the-mill criminal charges, if I may be allowed to say that, Your Honor. Crime is a crime, but however, I don't think she's a harmful person in terms of a new felon out there, Judge. That's it.
So I did review the PSR on Ms. Martinez, and counsel for the state is correct. I think I notated in terms of prior criminal history between 2000 and 2006, there were 36 entries for offenses that were all either controlled substance theft, things of that nature. I think there was some driving under the influence. So that was between 2000 and 2006. And then the Texas list went from 2012 to our current offenses. So it's been about 10 years of entries there. I did not count those, but it was an extensive criminal history to include. She's been to TDC, is that right, in 2014? Is that right?
That's correct, Your Honor. She went to the state jail facility.
And so here, she's on PR bond, or she's, out on bond on the UUV, 3563, and then allegedly picks up this drug case. Not good. The request to reduce the bonds are denied. So her bonds are going to stay the same. What I will tell you, Mr. Huerta, is that it doesn't appear we did not have settings for you. It looks like her arraignment in the 3563 case, you may have been out of pocket on that date. And this is what I was asking Mr. Marufo. Let's see. She was a no-show. How long has she been in custody?
Since November 27th, Judge?
Okay, so for our court hearing on the arraignment on October 18th, she was a no-show here. I don't know if I have a PR report on her. Well, we would have had the one for the new offense, but I'm thinking of the older case to see how she was doing. In any event, I think her prior non-compliance, criminal history, the fact that she was on bond, and lo and behold, we have another case, all lead me to the same point, which is the bond reduction is denied. Mr. Huerta, we're going to align your trial track to the one for, let me make sure, and it may already be, Myrna may have already with the
I'm
one
working
that,
on that right now, Judge.
okay, that we have for the drug case. Okay, so you'll get
Sure.
some settings here. All right.
Thank you.
Thank you, gentlemen.
Judge,
Thank you, Ms. Martinez. Who's next?
Your Honor, how did you want to handle the two different lawyers, Judge?
So, I mean, here's what we could do. I understand now why we did that. You know, Mr. Huerta was on first, but it's going to have to be PDs on the new case. So, Mr. Huerta, I mean, I really don't have a problem leaving you on the case, but, you know, generally I would just appoint PDs at this point on the other case, on the UUV, but I don't have a problem leaving Mr. Huerta on there because he's got the misdemeanor as well. And it, you know, it's kind of separate set of facts. It's not like they all arose out of the same incident and we just had a late indictment or anything like that. Okay, so I'm good to leave it as is. If it becomes an issue, let me know.
Thanks, Judge.
Mr. Huerta, anything?
Nothing further, Judge, and I'll speak with Mr. Huffman about anything about the kids.
Mr. Salcedo, what's the rec on Ms. Martinez's case? Do we have a rec yet?
Not yet, Your Honor. We were waiting for the labs on the manufacturer delivery case.
Okay, well, our jury trial's in July, so, to the extent, like I said, I showed, and I don't know if you saw if you could confirm this, but I thought she went to TDC in 2014, so. In any event, all right, thank you very much. All right, thank you, Mr.
Judge
Huerta.
Medeiros.
Yes, sir.
Thank you.
Who's next?
On page 25, Judge. Annex, when we have Eileen Ruiz.
Oh, this is another one where I have 2 cases and 2 attorneys. Mr. Harris, I believe this one's yours as well. Go ahead.
Okay. I know she has a colorful background.
Oh, hold on a second. We're gonna call a case.
Okay.
In
Oh, we
cause
lost your video. Go ahead, sorry.
in cause number 2022 0D04904 and 2022 0D01523, State of Texas versus Eileen Ruiz. Announcement of council, please.
Javier Salcedo, Assistant District Attorney for the state, ready to proceed.
Judge Rick Huffman, on behalf of Ms. Ruiz, we are ready to proceed.
Mr. Harris?
Robert R. Harris for the defendant. We are ready.
Okay, and just for purposes of the record, public defenders are representing Ms. Ruiz on 1523, cause number ending 1523, and Mr. Harris on cause number ending 4904. Bond hearing, I actually don't know if I went back and checked all of these. I know PD's filed a motion. I don't know if Mr. Harris did as well. State is prepared. They were on the docket, so state's prepared to go forward on both. Is that right?
That's correct, Your Honor.
Okay, Mr. Huffman, you can start.
Thank you, Your Honor. Your Honor, we're here requesting a bond reduction, and we're hoping the court would consider a PR bond in these cases. If released, Judge, Ms. Ruiz would be living with her grandmother. I have an address. It's here in El Paso, and I've confirmed that with her grandmother. She is welcome to stay there. Your Honor, it's my understanding that she was also doing okay on PR bond. Ms. Ruiz was reporting twice a week. She had basically started OSAR. I don't know if she was asked to continue OSAR, but she definitely did some OSAR. Your Honor, I think she has had struggles with self-medicating, and I talked to her about the possibility of Takumi, and I would hope the court would consider Takumi so that she can get services for her mental health. I think it would go far as preventing those issues with the self-medicating. It's my understanding that the basis for these PR bond revocations was a criminal mischief, basically an allegation that a flower pot was broken, and we have spoken to her mother, I guess the owner of the flower pot, and her mother has signed a non-pros. Really, Judge, we're hoping the court will consider releasing her again out on PR bond with Takumi and with OSAR, because Ms. Ruiz has 3 kids and she wants to help her kids, and I think with these services she can do that. I do not believe she has any violent criminal history. I believe her PR bonds have already been revoked. I mean, her misdemeanors have already been PR bonded, so we're just left with these felony cases. And Judge, that's all I have. I have an address for her grandmother's and a phone number as well. And like I said, Judge, she's more than welcome to go live with her grandmother. Thank you, Your Honor.
Okay, actually, Mr. Harris, do you have anything to add before I hear from the state?
No, I was gonna say, he's said everything I can think of. So I
Okay,
have nothing else to add.
and it appears that I'm just looking at the violation notice, that it was a new criminal mischief that was the basis for the PR violation. All right, Mr. Salcedo, go ahead.
Yes, Your Honor. As to the theft of property and unauthorized use of a motor vehicle, we would oppose any reduction in that, and also on the possession case. As to the theft of property, unauthorized use, the complaining witness is the owner of a dealership. He tells the officers that he shows up to his dealership and the vehicle is gone. He sees the vehicle is being driven a couple of days later, it's being driven by Ms. Ruiz. Ms. Ruiz doesn't make a mention to the officers when she gets arrested that, well, I did take the car, but it was only for one night. And so that tells me that she really not too concerned about the offense. The other case, the possession of controlled substance, she's again driving a vehicle with either altered registration and altered license plate. Officer pulls her over and they find she does not want to get out of the vehicle. They're trying to get her out. They finally bring a canine alerts to the presence of narcotics. And so that one happened in 4/18/2021. She's on a PR bond. And then we're back here a year later with new offenses. We have the unauthorized use, the theft of property. And then in November, we have the criminal mischief. And on that case, she goes over to and let me make sure I get this right, a lady by the name of Deborah Michaels. And she goes over to the residence because this lady, Deborah Michaels, it might be the grandmother, she's taking care of the grandchildren. She's got custody of the grandchildren. She goes over to the residence. Grandmother does not let her in because she's got custody, says you're not going to see the kids. Mom decides to break the windows to the house. And so if she's going to go back to the residence where she committed the criminal mischief, that's also going to be problematic. As far as the history is concerned, Your Honor, she does have, and let me pull this up. She was convicted for a possession of controlled substance in 2021. She has a bunch of others that have been dismissed. Possession cases, assaulting, resisting. She also has a probation revocation back in 2017. She also has a federal charge where she was convicted for harboring illegal aliens or harboring undocumented people. So, although
Mr.
not,
Salcedo, can
yes.
you tell me a little bit in reviewing the PSR, in other words, some of the criminal history? I chose some 2021 cases that were here in the 210 that it looks like they were dismissed. Can you tell me which ones those were?
Yes, Your Honor. The 20, let's see here. The 2020, or they were dismissed in 2021. That's a possession of a controlled substance, an assault on a peace officer, a resisting arrest that was tied with that.
Do you see the dismissals? Do you know why they were dismissed?
Yes, Judge, let me get into that particular. So the possession case and the assault, they were dismissed. They were to be used as extraneous offenses.
I know I signed those dismissals probably, but do you know who was handling them?
Mr. Cox. Did you get that, Judge?
I did. I was
Okay.
reading and listening at the same time, so
Yes,
sorry.
No, it's okay, Judge. I just wanted to, yeah.
Does she have has she ever been sent to TDC?
No, Your Honor. The only thing that she has was the federal charge that she did some time for.
Okay.
And
Alright.
Judge, I want to say she did 10, 11 months for that. So I don't know. I've got to get a disposition on that to see if she's still probation eligible, that kind of stuff.
Do we have a
Judge.
rec of these cases, Mr. Salcedo?
I'm sorry, Judge?
Do we have a rec?
I'm about to.
And while you look at that, Mr.
Oh.
Harris, I thought I heard it. I heard you. If you'll unmute. Were you trying to speak to me? Maybe not. Okay.
Judge, if I may, I just wanted to clarify that she would be living with her grandmother. The complaining witness on the criminal mischief case is her mother.
Mhm. Okay.
The recommendation right now, Your Honor, is 10 CDC.
Is that the first time this case has been wrecked? Or
Yes,
these
Your Honor.
cases? Okay.
No, we were just waiting for the P files to get filed, and now that we have everything here, we're recommending 10 CDC, given her prior state jail, that we can enhance her on the UUMB and the theft of property.
Okay, so they're actually thirds.
Yes, ma'am.
Okay, so the request to reduce the bonds is denied. We have our trial setting, I believe, also in July. It seems like we're early on, things are outstanding. We were just set for arraignment, I think, last week. So Mr. Huffman, you're set, actually, you're not set in July. It looks like you're set in June. And so if you need to come back to the court for anything, let me know. And I'm assuming you guys will be talking about that offer. But the bond reduction is denied. Thank you very much.
Thank you.
Who's next?
On page 26, Judge. Downtown, may we have Edwin Zuniga?
What? Oh, see, Mr. There he is. Okay.
In cause number 2022-0D02269, State of Texas versus Edwin Zuniga. Announcement of council, please.
Javier Salcedo, Assistant District Attorney for the state, ready to proceed.
Good afternoon, Your Honor. Eduardo Solis, Mr. Zuniga, and here at my office is Mr. Zuniga's mom.
Okay, Mr. Zuniga is appearing remotely from the downtown jail. We are scheduled for a bond hearing and a status today. Mr. Solis, you may proceed.
Thank you, Your Honor. We're here in a bond hearing. If you can recall, or Mr. Salcedo can recall, this is a young man that has had his mom present every step of the way on this particular case that we're here on today. Our hope was to resolve this very favorably to Mr. Zuniga. The situation that happened that we resulted in the bond revocation or capias was, so there's a young lady that Ms. Zuniga allowed to stay in her home because she's essentially homeless, but she goes to Socorro High School, and she is, for all intents and purposes, Mrs. Zuniga's girlfriend. Bear in mind, Mr. Zuniga has only turned 18. He'll be 19 in May, so he's still very young himself. Well, Mrs. Zuniga is driving her to Socorro High, and there's some sort of incident, and so Socorro PD, rather the resource officers are there, and so the police is called. There's a case filed, and then we're here on this bond revo or bond hearing. I can tell you that the young lady is still residing with Mrs. Zuniga, and she and her mom are willing to cooperate and say this was blown out of proportion and that they would sign a non-pros affidavit. Mr. Zuniga's mom has posted bond on the new case. There is this bond that's still outstanding, and then there was already an existing case companion to this case with Judge Anchondo, and that bond is at $10,000. It too resulted in a capias. So we're asking the court that the conditions remain the same, still with mom and dad. There was a vacation period that the parents took to Florida, but to abide by the court's conditions on bond, they did not allow Mr. Zuniga to travel with them. So he complied with conditions of bond. He's been monitored by PR. He was at home. And so we're asking the court to allow his release on bond so we can proceed to resolve the cases and hopefully allow some time for Mr. Zuniga to mature. I know that Mr. Salcedo was willing to work with us on that. I'm hopeful he's still inclined to do so. So those are the facts, Your Honor. I'm asking for a PR bond, Your Honor. Thank you.
Mr. Salcedo?
Yes, Your Honor. I'm a little concerned because the court heard this young man's case on a motion to recall the warrant back on October. And I believe the court was very explicit with Mr. Zuniga that the court was allowing him to have this opportunity to show the state whether or not he was going to be compliant with all of the terms and conditions, not only a PR bond, but possibly even doing something, maybe a deferred, maybe reducing the charge. And now we're here before the court because Mr. Zuniga, according to the report that I have, and there's several witnesses that observed this, independent witnesses, that he grabbed the victim by the neck and he forced her into the vehicle, or tried to force her into a vehicle, but she was able to leave. And so if they are living together, they are residing together, this may turn out to be not just an assault family violence, but it might be an impeding breath kind of case. So that is very concerning to the state, that given the opportunity that the court gave him and told him in open court, you need to comply with everything that they ask you to do. We're back here on a serious allegation. And so I would leave it to the discretion of the court, but this is concerning that we're not even 4 months later, we're back here before this judge.
All right, Mr. Solis, do you have anything else?
No, Your Honor, other than if the court would consider our request and the court would require that the young lady not live at the residence anymore. That's not necessary because Ms. Zuniga has already taken those steps. The young lady is not living at the residence anymore.
Now, I do recall, and I had made a notation regarding the request to withdraw the capias, and I do remember that hearing. And then we get this new case misdemeanor. So he bonded out on a 3,000 cash surety, and he's got it at 100,000 here, right, on this. So there's the only thing holding him is our case.
And I believe, Your Honor, if I may interrupt just briefly, I believe also Judge Anchondo has a 10,000 cash surety at the moment because there was a capias.
Okay. Well, I'm not inclined to maybe go as far down as you are requesting, Mr. Solis. But I will, the underlying, the robbery case, I know they're just allegations, but they're not good underlying facts. Yeah, I just can't get there. It's going to be a $50,000 split bond, 25,000 cash surety, 25,000 PR. He is to report twice a month to the PR bond office. He will have a curfew from 9 p.m. to 6 a.m. unless he is working or going to school. He is to possess no weapons. I believe in the robbery, the underlying allegation is that he had a taser and he threatened allegedly a woman with a taser. So no tasers. He may not change his place of residence or leave El Paso County without court permission. He will be subject to testing and is to use no illegal drug or alcohol. He is to have no contact and not be within 200 yards of any of the complainants, to include robbery and AFV complainant. So I thought I initially heard you say that, Mr. Solis, that she was living there, the complainant was, but now I don't think she is. So no contact, no contact whatsoever, and may not go near her. I don't know if they go to school together, if she was taking her, if he was taking her to school. Was he going to school there as well, Mr. Solis?
No, Your Honor, he was taking her to school.
Okay, so we can't be 200 yards from the school either. I don't want him near, if he's able to bond out, I don't want him near this individual until you all figure out a resolution. He has his trial date. Any other conditions, Mr. Salcedo?
No, Your Honor, I think you've covered all of them.
Mr. Zuniga, you have a very good attorney and clearly you have the support of your family, but I just don't think you're doing your part. So that is the reason for the bond, is what it is. prior non-compliance and future safety of the community and the victim. So with that, we have our settings. Mr. Solis, if you need to come back, please do, okay?
Thank you, Ron.
Thank you. Who's next?
On middle of page 25, Judge.
Mhm.
Annex, may we have Navarro, Juan Antonio Navarro? Annex, are you there?
Mr. Lopez, you scared him away.
I seem to have that
Just kidding.
aura. How are you doing, Judge?
I'm all right. It's weird weather. Weird weather.
It
makes
is.
Weird lighting, makes my eyes funky. I don't know what's going on. Is that Mr. Navarro?
It is.
Okay, go ahead, Mr. Navarro.
In cause number 2018-0D03194, State of Texas versus Juan Antonio Navarro. Announcement of council, please.
Javier Salcedo, Assistant District Attorney for the state, ready to proceed?
Your Honor, Louis Lopez on behalf of Mr. Navarro, ready to proceed.
And Mr. Navarro is appearing remotely from the jail annex. We're scheduled for a pre-revocation hearing. I think you all were working on some things, which is why we've had so many resets. We've had a few resets for various reasons, but I think if memory serves from the last hearing, Mr. Lopez, you were working on some things for your client.
Yes, Your Honor, his family came in and they brought me some information that I'd like to send to Javier. If he's the one handling the case, Mr. Navarro has not picked up any new charges. This is a non-reporting issue. He's been in custody 5, and so I'm hoping that I'll be able to convince Javier. And
Yeah,
I'm
Mr. Lopez, it totally cut out. So you received
Which one?
information. You received information, and after that, I didn't hear anything.
I received information from his parents, and I'm going to forward them to Javier. And I'm hoping, since Mr. Navarro has been in custody for 5 months, hoping that the court and Mr. Salcedo would be willing to put him back on reporting, considering the 5 months that he's been in custody. Like I explained to his parents and I talked about last week, he's never been incarcerated this long. And so this has been an eye-opening experience for him. And it definitely has matured him in a way that incarceration does for someone who's never been incarcerated.
Okay, so I feel like we're at the same point we were last time. We were waiting for information. So nothing has been conveyed to the state yet, Mr. Lopez?
I have that stuff, and I could forward it to Mr. Salcedo as soon as we hang up. And then if the court be so kind as to reset us later in the week, or if the court would want to reset us next week. I don't want this case to continue every 30 days or every reset. I think we can resolve this quickly. I just need to send him the material.
So if you are going to do that, then I will reset today's hearing for Thursday with the, if you're in agreement to have that without your client present. If not, it'll be 1 week.
No, Your Honor, we'll have it Thursday. Hopefully by then, Javier will look at the material and that'll give me an idea of what we're going to do if we can.
I see from the probation summary that we had discussed a 2 TDC rec. I think, what happened to that false report? Was that declined, the one from 2021, or is that still pending, or?
Yes, sir. That case was accepted and it's pending. It's 2022-0C0-4179.
Okay.
And that occurred December of 2021, where Mr. Navarro was intoxicated, called the police saying he was going to start shooting people, and he was going to shoot his girlfriend. And the girlfriend just wanted to get her items out of the residence. So that is still pending.
Okay. You know, we had discussed a rec of 2 TDC, and I'm comfortable with that, but I understand, Mr. Lopez, you need to do what you need to do. So we'll come back on Thursday, and if we have to, I'll put him for Tuesday if we need him here, if we still have hiccups. What I don't want is to have another free rebel beyond this small window, because if the information you're providing to the state is not so compelling that they're going to come back and tell me how much he really needs to stay on probation, I'm really at 2 TDC.
Yes, ma'am, I understand.
Thank you, Mr. Lopez. We'll see you on, we'll do 11 o'clock on Thursday.
That sounds good, Your Honor. I'll see you, and Javier, I'll send that to you ASAP. Is your email address J period Salcedo, or is it just, what is
It-
the?
It's J.A. Salcedo.
Okay, J.A. Salcedo. Perfect.
Yes,
I'll
sir.
send that to you in the next 30 minutes.
Got it.
Thank you, Mr. Lopez. Thank you, Mr.
Thank you,
Navarro.
Judge.
Who's next?
Top of page 23, Judge. And next, may we have Garza, Alfredo Garza.
Hey, Mr. Stevens, this is yours.
Yes, Your Honor. Good afternoon.
Good afternoon.
Martinez. It's Martinez. Ahí te vas, Navarro Juan. Con that. Navarro Juan, for me? Okay.
Is that Mr. Garza?
Yes, ma'am.
No.
Okay, let's get started. What am I hearing?
In cause number 2022-0D0-1666, State of Texas versus Alfredo Garza. Announcement of counsel, please.
Javier Salcedo, Assistant District Attorney for the state, right?
Brent Stevens for Mr. Garza, and we are ready, Your Honor.
And Mr. Garza is appearing from the jail annex. Mr. Garza, my understanding is we're scheduled for a plea today. Is that your understanding as well?
Yes, ma'am.
Okay, so in order to get started with that, I need to swear you in. Would you raise your right hand, please? Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down. Would you state your name and date of birth for the record?
Alfredo Garza, 7/1972.
Mr. Garza, as I mentioned, we are scheduled for a plea today. So there were documents that you should have reviewed with your attorney, the first of which is marked as State's Exhibit number 1. Those are the plea papers. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Garza, do you recall reviewing State's Exhibit number 1, the plea papers, with your attorney and signing that document?
Yes, ma'am.
Did you understand everything contained within the document?
Yes, ma'am.
Mr. Stevens, have you had more than 10 days to prepare a defense in this case?
We have, Your Honor.
And did you explain the plea papers to your client?
Yes, Your Honor.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
I do.
Mr. Garza, are you satisfied with your attorney's representation of you?
Yes, ma'am.
Okay, Mr. Stevens, any reason to believe your client is not presently competent to enter his pleas?
None, Your Honor.
Mr. Garza, have you ever been found mentally incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas. So are you a U.S. citizen?
Yes, ma'am.
Where were you born?
San Jose, California.
Okay. In this case, you're charged by indictment with 2 counts of failure to register for each of these cases. Well, let me ask, as to count 1, what is your plea, guilty or not guilty?
Guilty.
As to count 2, what is your plea, guilty or not guilty?
Guilty.
Are you making each of your pleas freely and voluntarily?
Yes, ma'am.
I will find you are making your pleas freely and voluntarily. Mr. Salcedo, would you summarize the evidence, please?
Yes, Your Honor. Had the state proceeded to trial, the state would have proven beyond a reasonable doubt that on or about the first day of March 2022 and adhered to the presentment of the indictment in the county of El Paso and state of Texas, Alfredo Garza, that then and there, while knowing that he in chapter 62 of the Texas Code of Criminal Procedure.
Mr. Salcedo, can you go back a little bit? It cut out.
Yes. To what point, Your Honor?
Erica.
Knowingly, then and there, while knowingly.
While knowing that he was required to register under chapter 62 of the Texas Code of Criminal Procedure because of a reportable conviction based upon indecency with a child, sexual contact, and after having changed his address failed to comply with a requirement of Chapter 62 by failing to report in person to the local law enforcement authority in the county in which the defendant knew residence was located, namely the El Paso County Sheriff's Office Short Unit, and the defendant failed to provide the law enforcement authority with proof of identity or proof of residence within the latter of the 7th day of changing the address or first date that the local law enforcement authority by policy allowed the defendant to report. It is further presented that prior to the commission of the charged offense on the 28th day of December 1994, in cause number 92-416151 in the 237th District Court of Lubbock County, Texas, the defendant was finally convicted of the felony of driving while intoxicated, third or more. It is further presented that prior to the commission of the primary offense and after the conviction in cause number 92-416151 was final, the defendant committed the felony offense of failure to register offender and was finally convicted on the 26th day of April 2016 in cause number 2015-406212 in the 137th District Court of Lubbock County, Texas. As to count 2, the state would have proven beyond a reasonable doubt that on or about the first day of February in the county of El Paso and state of Texas, Alfredo Garza did then and there, while knowing that he was required to register under Chapter 62 of the Texas Code of Criminal Procedure because of a reportable conviction based upon indecency with a child, sexual contact, intending to change address, failed to comply with a requirement of Chapter 62 by failing to report in person not later than the 7th day before the attended change of address to the local law enforcement authority designated as the defendant's primary registration authority by the Texas Department of Public Safety, namely the El Paso County Sheriff's Office Court Unit, and by failing to report to the parole officer supervising the defendant, namely Sandra Quiroga, and by failing to provide the law enforcement authority and the officer with the defendant's anticipated move, date, and new address. It is further presented that prior to the commission of the charged offense, on the 28th day of December 1994, in cause number 92-416151 in the 237th District Court of Lubbock County, Texas, the defendant was finally convicted of the felony offense of driving while intoxicated, third or more. It is further presented that prior to the commission of the primary offense and after the conviction in cause number 92-416151 was final, the defendant committed the felony offense of failure to register sex offender and was finally convicted on the 26th day of April 2016 in cause number 2015-406212 in the 137th District Court of Lubbock County, Texas. At this time, we would offer to take the exhibit number 1, the plea agreement, and exhibit number 2, the Article 3914 into evidence.
Any objection?
Judge, I don't have any objection to the evidence. I would point out that we have agreed to plead to a third-degree felony.
Okay, so with that states 1 and 2 are admitted. What is the plea agreement?
Yes, Your Honor. The recommendation from the state is 3 years confinement in the Texas Department of Criminal Justice Correctional Institutions Division with no period of community supervision.
Mr. Stevens, is that your understanding of the plea agreement?
I missed part of that. It was 3 years in the Texas Department of Corrections, correct?
That's what I heard.
Yes, we are in agreement, Judge.
And Mr. Garza, is that your understanding of the plea agreement as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. And I see, I had these and I show that the plea papers reflect a third-degree felony, and I was just double checking the indictment. So we're talking about the enhancements are going away. Is that right?
Yes, Your Honor.
Okay. All right. Mr. Garza, understand that the plea agreement is not, I don't even know if I said this already. The plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, we may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Garza, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
It was signed by your attorney and signed by the court as well. And on your pleas of guilty and the evidence introduced, I will accept your pleas and at this time find the evidence substantiates your guilt. I will find you guilty of the offenses of failure to comply with the registration, the third-degree felony without enhancements as to each count 1 and 2, and sentence you according to the plea agreement at 3 years confinement in the Texas Department of Criminal Justice Institutional Division. For each count, those of course will run concurrent with one another and you will receive credit for any and all time that you have served. Is there anything further, Mr. Stevens or Mr. Salcedo?
Not from the state, Your Honor. Thank you.
Not from the defense either, Your Honor. Thank you very much.
Thank you. Good luck to you, Mr. Garza. Okay, who's next?
Top of page 26, Judge.
Mhm.
And annex, we have Villanueva, Daniel Villanueva.
Yes, give me 1 second.
Yes, sir.
Is that Mr. Villanueva?
Yes, ma'am.
Okay, ready?
In cause number 2019-0D06356, State of Texas versus Daniel Villanueva. Announcement of counsel, please.
Javier Salcedo, Assistant District Attorney for the state, ready to proceed.
Brent Stevens from the Public Defender's Office. We are ready to proceed as well.
And Mr. Villanueva is appearing remotely from the jail annex. We are scheduled today, Mr. Villanueva, for a plea of true. Is that your understanding of what we're doing here today?
Yes, ma'am.
Okay, so in order to get started with that, I need to swear you in. Would you raise your right hand, please? Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down. Would you state your name and date of birth for the record?
Daniel Villanueva, May 2nd, 1980.
Mr. Villanueva, are you the same individual who on June 9th, 2020, entered a plea of guilty to the offense of possession of a controlled substance in penalty group 1 in an amount less than 1 gram and was placed on deferred adjudication for a period of 2 years? Are you that same person?
Yes, ma'am.
Mr. Stevens, do you waive formal reading of the motion to adjudicate in this case?
We do, Your Honor.
Mr. Villanueva, there were documents that you should have reviewed with your attorney, marked states 1, 2, and 3. Those are the stipulations and waiver in this case. Do you recall reviewing those with your attorney and signing those documents?
Yes, ma'am.
You understand everything contained within those documents?
Yes, ma'am.
Mr. Stevens, did you explain those documents to your client and the consequences of signing them?
Yes, Your Honor.
Mr. Villanueva, are you knowingly and voluntarily waiving the rights explained in the documents that you signed?
Yes.
And do you understand that by signing those documents, you're giving up certain constitutional rights? Do you understand that?
Yes, ma'am.
Do you understand you're making a judicial confession?
Yes.
Do you understand that on a plea of true and all reasonable probability, I will find the allegations in the state's motion to adjudicate to be true? And in all reasonable probability, I will find you guilty of this offense, possession of a controlled substance in penalty group 1 in an amount less than 1 gram. Do you understand that?
Yes, ma'am.
With regard to the motion to adjudicate, do you wish to enter a plea of true or not true?
True.
I'm sorry?
True.
Other than the plea agreement reached between you and the state, which I believe is 6 months state jail, are you pleading true because the allegations are true and for no other reason?
Yes.
Okay, I will find that you are making your plea of true freely and voluntarily. And in fact, Mr. Salcedo, is that what the agreement is, 6 months state jail?
That is correct, Your Honor.
And Mr. Stevens, is that your understanding of the plea agreement?
It is, Your Honor.
And Mr. Villanueva, is that your understanding as well?
Yes, ma'am.
So at this time, I will accept the plea agreement, admit the state's exhibits 1, 2, and 3 into evidence. The court will take judicial notice of all documents in the district clerk's file in this case. Sir, based on the evidence presented here today and on your plea of true, I find there is sufficient evidence to support the allegations in the state's motion, and I find you guilty of the offense of possession of a controlled substance in penalty group 1 in an amount less than 1 gram. The judgment in this case is hereby amended from 2 years deferred adjudication to 6 months confinement in the Texas Department of Criminal Justice State Jail Facility. Your sentence, you will receive credit actually for the time that you have served in this case. So you have, according to my docket, he had close to 80 days. It'll probably be a little bit more. Is there anything further, Mr. Stevens or Mr. Salcedo?
Not from the state, Your Honor. Thank you.
Not from the defense, Your Honor. Thank you very much.
Good luck to you, sir. Who's next?
Top of page 24, Judge. Annex, may we have Ruben Mendoza?
Coming up.
Is it just 2 probation cases? Is that what it is? Or I'm sorry, 1 probation case and 2 new cases. Sorry.
Yes, ma'am.
Okay, let's go.
In cause number 2017 0D06448 and 2022 0D02199 and 2022 0D02225, State of Texas versus Ruben Mendoza. Announcement of council, please.
Javier Salcedo, Assistant District Attorney, right, for the state rate to proceed, Your Honor.
Rick Huffman, on behalf of Mr. Mendoza, we're ready, Your Honor.
Monica Lerma on behalf of the Adult Probation Department.
Thank you very much. We're scheduled, yes, for a probation status hearing and then the 2 status conferences. Let me start with the status conferences. What are we doing? Have you all discussed the cases? I showed from the probation summary that we were looking at, I think there had been rec at one point of 4 TDC, then it went to 5 TDC. And I can't recall offhand. Let me look at the probation report.
Yeah, I think the issue, Judge, was it had to be 5, the minimum of the cases on probation for. So I think the rec right now is 5 on the probation case and 4 on the pending cases.
Yeah, and this was a situation where Mr. Mendoza just kind of, I think he'd been given 1 shot once he was not in compliant with his treatment, and then lo and behold, we lose him again. And so although it is a recommendation that he be modified to some residential treatment, the court is not on that page. So 5's the minimum. I'm good with 5. Have you had enough time to look at the newer cases, Mr. Huffman?
I have, Your Honor, and I have discussed those cases with Mr. Mendoza.
Okay.
And Judge, we are in agreement with the offer. I just kind of wanted to confirm that I was hoping the part of the offer could be to give Mr. Mendoza credit towards his probation case for all the time that he's been doing. But I think, with that, we're in agreement, Judge.
Okay, well, what do you think about that, Mr. Salcedo?
Yes, Your Honor. I'm actually looking at the state jail case, and I'm willing to dismiss that with a plea of true on the probation case and 5 TDC on the newly indicted case.
It's my understanding that it was 4 TDC on the new cases, because I think he's got some more time on the probation cases.
I'll let you all look at that. We're coming back on the 7th of February, so it's in a few weeks. If you have any questions, need to talk with me about it, let me know. But I think we know where we're headed on this.
Yes,
so, okay. Well,
Yes,
thank you very much. If I don't hear from you before then, we'll see you on the 7th.
Thank you, Judge.
Lerma, thank you very much.
Thank you. May I be excused, Your Honor?
You may.
Thank
Sorry
you.
you waited so long.
Not at all. Not at
Okay.
all. Thank you.
Mr. Mendoza, do we have anybody else?
I believe not.